French-British rule in India introduced the common law into this country. This provided the basis of our present legal system. The law-making function of the judges in India is the same or even more comprehensive due to the power of judicial review of legislation exercised only by our judges, which is not given to the judges in England. The development of law by judicial decisions on the basis of common law principle in India follows the same pattern as has been followed in the England. When a question arises as to what the law is on a particular point, we turn to legislation or rules which may exist. In their absence, we turn to general principles and act accordingly. These principles are found embodied in judicial decisions and are being created and developed every day by the judicial decisions. For example, in Additional District Magistrate Jabalpur versus Shivkant Shukla, a case of 1976 decided by Supreme Court, the question which arose was whether the right to personal liberty under the common law and the relevant statutes became unavailable only because the fundamental right to the personal liberty guaranteed by Article 21 was suspended during the emergency. It is submitted with great respect that the following legal position might have been found relevant in considering the question of, number 1, the common law, custom, and general principle of justice, equity, and good conscience, which are drawn upon by the courts both in England and India, provide the basis and the environment in which statutes are enacted. It is a settled principle of the interpretation of statutes that the pre-existing common law and the principles of justice, equity, and good conscience are not altered by statute law except to the extent of repugnancy between the two. Secondly, in spite of much of statute in England as in India, it has been observed, quote, it is only where constitutional law is concerned in that small but vital sphere where liberty of the person and of speech are guarded that it means the rule of the common law. For here alone has Parliament seen fit to leave the law substantially unaltered and to leave the protection of the freedom of individuals to the operation of the common law. The same observation would hold good in India inasmuch as freedom of individuals is assumed to be the rule of law except insofar as statutes restrict it. Even in England, the sovereignty of Parliament has meant the supremacy of existing law so long as Parliament was fit to leave it unaltered. It is well known that Parliament identified itself with the cause of the supremacy of the law and did not alter by statute the basic principle that individual enjoys all the liberties unless restrictions on them are placed by the statutes.